Maybe just a foolish dreamer, but I don't care. But I know my dad way, searching for that silver line, horizon that I'll never see. Good morning. I see people jumping on already. A couple minutes early. Thank you. Hey, I see a bunch of folks are jumping on. Thanks for being here early. We give people to a couple minutes after. That's what I've typically done. And meanwhile, you're listening to the legendary and fabulous Commodores. Their song from 1977, I believe, called Zoom, which I started using as my theme music at the beginning of the pandemic. Wish I'd taken their advice and bought Zoom stock. Anyway, enjoy Lionel Richie, Clyde Orange, and we'll start up here in a couple of minutes. One minute. See some good friends on. Thanks for joining. Some of you I don't know. I'm delighted that you're here as well. Hope you got your coffee. I'm going to be moving fast. All right. Good group this morning. I'm going to do the professional fade. For those of you that just joined us, that is the legendary and fabulous Commodores featuring Lionel Richie from my old hometown, Tuskegee, Alabama. You want to hear about Tuskegee? You can buy the drinks sometime. Welcome. I'm John Miller, the senior attorney and owner of Rock Solid Law and Title. Started the firm in 1991 in here in Ponte Vedra, and you can see the sun pouring in. It's a beautiful day in Ponte Vedra Beach, Florida. Why talk about estate planning? The reason I started in the 90s practicing in the area of estate planning was because I represent entrepreneurial small business owners, and we were planning the future of those businesses. We could not adequately plan for the future of those folks unless I got to know them personally and was able to plan for the future of their family, inclusive of where their wealth's going to go, protecting their legacies, right? And in the very best moments of this area of practice, giving people peace of mind, which is really what it's all about. There are a lot of talented attorneys who can draft documents for people. The difference we try to make, two differences mainly at Rock Solid, is we want to have a conversation and understand what your values are, right? And we want to then apply those values to a plan which takes care of you during your lifetime and takes care of those you love afterward. And that's what we're going to talk about this morning. What does that mean? What is included in that? Now, we started doing these webinars at the beginning of the pandemic, actually, and have continued them because, like yourselves this morning, there seems to be an interest. So somebody, Wanda, good morning. Thank you for opening the question and answer panel. Always good to see your name at least, and you in person when possible. That panel is right here. I will try to get through the material efficiently so that I can leave time for questions and answers at the end. As always, if you have a question that's too personal to throw out on this webinar where other people who you don't know are listening, feel free to write us at questions, that's plural with an S, questions@rocksolidlaw.com, and we'll get you an answer to that. In some instances, we can answer the question. In some instances, we need to talk about it. We can either arrange a phone call or a consultation. And I'll go ahead and let the rabbit out of the hat just for showing up and spending this time with me this morning. If you do need to consult with us here, you let them know that you attended this, and we will waive the consultation fee, which is an almost $500 savings. So we just feel it's so important that people participate in estate planning. So the stats are horrible. Americans can procrastinate almost nothing as well as putting off doing a last will and testament or a trust. And really about 80% of folks either have no planning at all or have a plan that's so old it's really pretty ineffective, or the laws have changed. So we love updating. We love bringing in new people to Florida to make sure their plan is under our laws now that they live here. And we love working with people that just haven't gotten around to it yet and don't feel like the Lone Ranger, because a huge majority of the people that we have the privilege of representing say at some point in the conversation, oh, I've been meaning to do this for fill in the blank, 20 years, and I just never get around to it. I started it once when the kids were born, but we never finished up. Don't sweat it. I like to tell a story on myself. When we had our daughter 15 years ago, my wonderful wife bugged me to get a plan in place. And I, after a bit of reminders, managed to update our plan to include our child. Those of you that know me personally know it was 6 years later that our little boy was born. And once again, my brilliant wife said, you really should update the plan. And you know the story of the cobbler. The cobbler's children have no shoes, right? We take care of ourselves last. It was a good 2 years later that I got around to updating the plan. I'm glad to say that it is fully updated now and has been updated since. But for those 2 years, I like to say that my dear son, the carrier of our family name, the scion of the future of our family tree, and the fruit of my loins, was known in my planning as, drum roll, all afterborn children. Now, he would have been taken care of, but I'm sure that if that language had been left there, it wouldn't have given a warm, fuzzy feeling after I was gone. So that brings me to my point of protecting your legacy is one of the most important things we do. We can't stop anybody in America from fighting or bringing a lawsuit, but we can set up a plan where it's much, much harder for them to do so. We keep your estate out of court, no judge involved, and we get things done the way you want them to do. So I'm going to jump ahead because next month, I'm going to talk about new Floridians, and that is people that have come to our state who might have an estate plan elsewhere. So if you know people that are reasonably new to Florida, and reasonably can be as recent as 10 years, because most people don't think about updating their estate plan as the first thing they do when they move, I would like you to invite them to join me next month. You, of course, are welcome if you want more. And then the month after, I believe, I'm going to do Trust 201. I call it, this is Estate Planning 101. I call that 201 because I get a little bit more into the weeds about the different types of trusts. I'm going to talk this morning a little bit about the living trust, the revocable trust. In the other webinar, we'll get a little bit into irrevocable trusts and what they can do. Basically, just for your thumbnail sketch Cliff Notes version of knowledge, they are typically either for tax planning, meaning not paying more to the government than you have to, or for asset protection purposes. There are other reasons for irrevocable trust, but those are the main ones. So let's talk about why an estate plan. What does it do for you? Most everybody knows they need one, and truthfully, probably the lowest 5% of economic citizens really don't need one because nothing's going to happen when they go. Assuming they don't have real property and they just got stuff and they put their kid on their bank account, everything's going to work out fine. But for the rest of us, we need to put a plan in place, first and foremost, to take care of ourselves during our lives. What do you mean? I didn't think an estate plan had anything to do, but what happens after I die? Wrong, wrong, wrong. So the first thing you want to avoid is having to have a court appoint someone to manage your affairs if you're not able to. So if you don't have a proper power of attorney and a proper healthcare surrogate, sometimes called advance directives, and you lose your marbles, your family has to go to court and fight over who's going to be in charge of you. And I bet some of you are thinking right now, ooh, I hope it's not fill in the blank, right? Well, fill in the blank is going to be the person fighting the hardest. So let me tell you real quick about Groucho Marx. Didn't think you're going to hear about the Marx brothers today, did you? Groucho Marx, of course, was a Hollywood star and unbelievably wealthy for his time. Like so many Americans, he just couldn't be bothered with getting his estate plan together. Sadly, he outlived his ability to take care of himself. He basically, it's like now everybody who goes into dementia can't take care of their affairs. Well, what do you think? There is all of Groucho's wealth and nobody put in charge of it. So a whole bunch of people thought that they ought to be the one to be in charge of his money. So, I don't know if you guys are Marx Brothers fans, but they were hilarious. And there's this picture of this little old man sitting in the corner of a courthouse with a blanket draped over his knees in his wheelchair, crying as people fought over who was going to get to be appointed by the court to be his guardian because they cared more about his money than they did about him. He could have avoided all that. Sad thing about Groucho, not long after that court battle, he died. And his estate had to be probated, and the fight happened all over again. And where do you think the money came from? His own money. Isn't that awful? So first thing we can do is avoid all of that. And it's simple. As part of every estate planning package, from a simple will all the way through a complex trust, we are going to include a family power of attorney, which is statutory now. The law changed in 2011, and I'm not going into that today because there's a whole webinar on it. And if you haven't been on our past webinars, you're welcome to go to rocksolidlaw/videos. I think it is. You'll find it on the webpage and watch them. All you got to do is let us know you're not a robot, and there's lots of education there. So what does a power of attorney do? You're essentially giving someone you know, like, and trust, a fiduciary, we call it. They're fiduciaries all through estate planning. The ability to do the things for you that you could have done for yourself if you were still able to do them. Make sense? Okay. Then, because of that statutory change 13 years ago, power of attorney is a long document. I just had somebody bring me one. I said, "Where'd you get this?" She said, "The interweb." Unfortunately, the person is not able to execute a new one in proper form, but we think we can get this one to work. But please, 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 uh, don't just download internet documents. I had a business client bring me a document one time, and there's a word in there I didn't know, a term of art. And listen, I've practiced since 1984, so I don't know everything, but I know most of the terms of art in business law. And I looked it up, and it came from Canada. It was a term under Canadian law. These Floridians had downloaded a contract from the internet, not realizing that it was drafted under Canadian law and that they had agreed to be governed by Canadian law. So we were able to help them out a little bit. So my point is, downloading from the internet is dicey. This is a really important step. When you do it, you need to do it right. Okay. Now, the other thing I told you a little bit different about us. One, we're values-based. We want to figure out what matters to you and write the plan so that it works according to what you tell us. You tell us in plain English how you want things to go, who you want stuff to go to, how you want to be treated, and at what point in time in the future your minor or maybe young adult children inherit, because we try not to get anybody to inherit $1 million at 18 or 21 because it's all gone. Stats show that's gone in a year, and we can do that with a trust. Anyway, the other piece we do that a lot of firms don't do is called funding. It's a simple concept. We help you transfer title to your assets into your trust if you have one, because your trustees are only in charge of what's in the trust. Most firms give you a sheet of paper and tell you to go get it, which I consider borderline malpractice to go do it yourself, because the stats show well over 90% of people never do it. And therefore, they've got a piece of paper, a pile of papers that are entirely ineffective and are going to court anyway. Ticks me off. So it's like if you were going on a trip and you grabbed your suitcase and didn't put any clothes in it, right? So without the funding, you're flying naked. Don't worry, if you work with my law firm, we don't let go of you until the funding is done. We are going to lead you the horse to water and help you drink before we let you go. All right. So I talked about the power of attorney. You need another power of attorney. This is a specific power of attorney called a healthcare surrogate. It can go under other names, but that's what we call it. And this is just so somebody can deal with the hospital staff, your doctors, your nurses, all those things regarding medical care. Very short document. Why is that important? I just told you that the power of attorney is a very long document. It's bigger than most wills and some trusts. The short document is because you want the statutory form healthcare surrogate so that the doctor doesn't have to send it to the legal staff of the hospital and have them make sure you have power to make the decisions for this person who needs surgery. And that person who needs surgery, by the way, is you if you've executed this document. So we got a nice short form that gets you all the care you need when you are most in need for your health. All right. Along with that document, you're going to get a HIPAA release so that your people that are taking care of you can get all the medical records they need. So these are things that take care of you while you are alive. So most people think that an estate plan, a last will and testament, is only for after you're gone, but they're not. You need them for while you're alive, and so you won't be a burden to other people, and so that you pick who's going to take care of you when you need it. All right. Next after that, another drum roll, the very worst named document, in my opinion, in all of the law. A living will. People come to me all the time and say, I need a living will. What they mean is they need a last will and testament. They are not at all the same thing. If you take nothing else from here, never ask anybody else, tell anybody you need a living will, because a living will is how you want to be cared for in your last illness. In other words, when you're dying. It is the instrument which says that when I am vegetative state and not expected to recover, that I want you to take me off life support. I want you to stop administering new medical techniques. If you find cancer after I'm already brain dead, do not give me chemo. Let me go. Okay. Now, we will provide the short form living will that comes out of the Florida statutes if our clients want. We also give them the option to execute a similar document that is called Declaration to Physician regarding life support. This instrument is, I think, better in the practice. It's developed more recently among quality estate planning lawyers nationwide, and it is consistent with hospice's wishes. Some of you may be familiar with the wishes of hospice, of how you want to be treated. It has a lot of things about your care during that final illness, all of which are elective. You can pick and choose which ones you want. One of my favorites, not a surprise to those you know me, I want my favorite music played in the room when I'm about to pass over to the other side. There are several genres of music that I seriously do not want played in my my last hospitalization or hospice. So all sorts of things. Good for you, good for the family. I think it's a wonderful document. All right, so now we've taken you up to your last illness, and the next document that we need to talk about is the last will and testament. Everybody knows what a last will and testament is or has heard of one. What most people don't know is that every last will and testament must be submitted to the court. We're very fortunate here in Northeast Florida. We have wonderful judges in the probate division in all the counties. However, and with all due deference to my many friends who are in my age group and younger who have become judges, you all know that judges are either elected or appointed by politicians. I like to say regularly there are two things. I'll back up. I like to say regularly that Americans love to argue about all sorts of things, but there are two things we agree on. One, that we do not want to pay any more taxes than we have to. And we agree with that. And our clients only pay the mandatory, not the voluntary taxes. And two, that we don't want the government ultimately to be in charge of our decisions about ourselves. And by having only a last will and testament, you are ultimately making the decision that a judge will be in charge of your affairs. You will have left instructions. You will have chosen your preferred personal representative. And assuming they are properly eligible, there's a good likelihood they'll be appointed, but there's a chance they won't. Wills go through court. A probate case is open. Creditors are notified. They have 3 months to make a claim for what they claim that you owed them, and your heirs then have to sort that out. So in almost no case does that process take less than 6 months, and in many, many cases it takes a year or even up to 3 years or more, particularly if the family is fighting. What I don't like about probate is that it gives the arena in which families fight, right? If you're already in court and somebody has a beef with their sister or brother, it's pretty darn easy to sue them. If you're not in court, they've got to make the decision to undertake the expense of filing a lawsuit against their sibling. So I have just seen too many instances where brothers and sisters are never going to talk again. And short of that, it's stressful and it's time consuming. There is no heir that wishes to be in the courtroom rather than on the beach, on the golf course, on the tennis court, whatever it is they prefer to be doing. So a last will and testament is basically good for someone who doesn't have a lot of assets. It can also be used with somebody that might have only one child or heir if beneficiary language is placed on every single thing they own, including real property, which is a whole nother subject. I'm not going to get into that today. So in certain circumstances, we can keep somebody out of probate through planning inclusive of a last will and testament. Now, important point, and I'm going to move on to trust in just a moment in the little bit of time we have left. Important point. A last will and testament that is not in conjunction with a living trust, a revocable trust, is different than the last will and testament that is part of the package with a trust. The latter is called a pour-over will. Its only job is to move whatever assets somebody failed to put into the trust over into the trust. So it's a very simple probate if necessary. Why do we include that? It's a safety net, because when we finish with our clients, they have everything retitled to their trust, unless they just refuse to put something in there. However, we don't live with them from then on. And if they go open an account in their own name, don't put a beneficiary on it, don't list the trust on it, that has to go be moved into the trust after they die. So that's what that pour-over will is. We include it in every trust package, but we hope it's obsolete from the start. Void ab initio. Ha, I worked some Latin into this half hour. Okay, so all of those things are in every package we do, along with a couple of other items. I have a relative who's only alive because of an organ donor, so we provide one for free in every package if people wish to do so. Your choice, but we will do the legal work for nothing. We also try to do some things to take care of young adult children, 18 to 21. We will provide documents for a family to help the parents help them, and also a pre-need guardian, both for yourselves and for any minor children you might have. So you can pick who is the person that's going to be in charge of raising your kids if you're not here to be able to do it. So a living trust, a revocable trust, an inter vivos trust, more Latin. Those are all the same thing, okay? It means a trust that you create that you can make changes to whenever you want. The downside, no asset protection, unlikely to have tax benefits. Those are the main ones. The upside, avoid probate. Don't go to court. And through a trust, you can assert your will on where your stuff goes over time after you pass away, which is not possible with a last will and testament. Many people would rather have their estate doled out over time to their children, perhaps starting as early as age 25. I'm seeing 30, 35, 40, 45 even these days of percentages being distributed. Why the 45? Well, no kid really wants to wait for their inheritance, but if they don't get it till 45, probably securing their retirement, right? So parents that are thinking long-term of setting their kids up for success are phasing the distributions out over time. What's the negative? The trust has to remain in effect. So whoever you've appointed successor trustee has a long-term job. That can be somebody in your family, you know, like in trust, who's got some good financial sense. It can also be an independent person, and we have relationships with a few of them that we can recommend that you interview. I have no dog in that hunt, so whoever you choose is whoever you choose. More often, it is a family member, and when possible, one of the next generation, so they're here after you're gone. So a living trust completely avoids probate, keeps you out of court unless somebody files a lawsuit for breach of it, right? Which means that after the second of a couple or a single person passes on, all that's recorded with the court is a notice of trust. No probate action is required. And by the way, we will help a family who is not fighting through probate, but I've just made the decision that I don't want to be involved in intense litigation anymore. And therefore, we will not do a probate for anybody that's fighting. We can refer that out. So we would prefer to plan with people so that they have a trust, so that they never go to court, and so that their wishes are followed well into the future of how that family is going to be protected. We also take into considerations the contingency. What if the sad case occurs where one of your children does not outlive you, but they leave children? You could put a trust in place for those minors. There are, every family has a different story, and whatever that story is, we can write it into your trust, their trust, so that their wishes are honored, and so that the plan that they create helps future generations of their family tree to succeed. You know, um, the stats show that within 3 generations, many American families go from poverty to wealth and back to poverty. The trust can help that break that cycle. You notice the family names that you know, the wealthy families of America, they always keep the real property, the family compound, the vacation house, and everything else in the family. They don't lose it through the probate because they plan ahead. And this is not an overly expensive process. I find that for most of my clients, it's less than a single vacation for the family. And now don't tell me you just went tent camping out in a state park, because that doesn't count. And I love to camp. So typically less than a family vacation. And usually you don't have to do a lot to it unless the situation changes over time. We do recommend that people update them periodically because things do change. And certainly putting a trust plan in place is less expensive than having your family go through probate, both on a financial basis and on an emotional, especially on an emotional basis. So that's basically Wills and Trusts 101, what an estate plan is. If any of you guys jumped on late, I told the folks on here that just for attending this morning's webinar, we will waive our usual charge to sit and discuss your situation with you. It's called a consultation. So mention that when you call Alex at our front desk. We're 241-1113, or you can go online to our website, rocksolidlaw.com. Come in, talk about it, no obligation. And once we've talked about it, I will give you a flat fee. We will tell you how much it's going to cost you to get this done. People ask all the time, what does it cost? I don't know. I don't know your family. I don't know your needs. We will give people options and you can choose. Our whole goal is to educate you so that you make the best decision about how you want your family taken care of. So I want to reiterate that no lawyer can tell you how much the services are going to cost because they don't know what you need until they talk to you. So these people that throw out the bait and switch lowball numbers of a will are really doing people a disservice because they're not fully taking care of you during your lifetime and those people you love after you're gone. So let's see. I have a couple of questions. I'm going to roll right into those. I know I went a little long this morning. I tried to get done by 1:30, but it's so important to me, and I am just I just am engaged in a quest to get people to do their planning. So here come the reading glasses. There's somebody anonymous. What if you have children and aren't married? I don't know who I would list as a oh, you don't have children, beneficiary, or who to select as POA or healthcare surrogate. And it goes on, I don't have any real assets other than a car and furniture. Are all these forms really necessary when there aren't a children or a husband? Well, there's a whole bunch of questions in there. But at the beginning, I was mentioning that if you don't have real property, and if you know who you want stuff to go to, then you might be able to put death beneficiaries on your bank account and anything else you own and clear yourself of probate. And, you know, if your assets are $100,000 or $200,000 or under, you may not need a plan. By the way, for people that are really looking for a very, very, very basic plan of the kind that we don't provide, I have lawyers I'll refer you to, no problem at all. But you do have to know who you'd want your fiduciaries to be. So when you're thinking of a power of attorney, it needs to be someone you trust who is smart with financial issues. And when you're thinking of a healthcare surrogate, it needs to be someone you trust who would be able to make good decisions in consultation with your healthcare providers. All right. Car and furniture. Okay, the DMV is a specific situation. Usually they'll transfer title to a family member with a death certificate. Furniture, if that's all you've got, mostly whoever your closest person um, is going to get that. Somebody's going to have a key to your apartment, I guess. So some of the forms may not be necessary. I wouldn't say it's when you don't have children or a spouse. I would say it's more when you don't have enough assets to be passed through either the will or the trust. Okay. Because most people have somebody in their life or something that they care about. You know, a lot of people want to leave things to a charity. All right. So, I don't know. I hope that's a decent answer to that question. Your fact scenario may be one where just with the power of attorney and healthcare surrogate, you'd be fine. But again, unless you sit and talk to somebody who knows this field of law, I'm not confident giving you advice specifically on what you need to do. Pardon me, which disclaimer, nothing I've said can be taken as advice for you particularly. I'm just trying to educate you generally on the nature of the law in this area. One more time for hanging out with me a little bit this morning. If you want to reach out to us on the phone or at rocksolidlaw.com, we'll be happy to have me or another lawyer sit with you, talk about your situation, and give you our very best thoughts on your scenario. And then you can choose how you might want to go forward, hopefully with us, but some people choose to work with somebody else. And if that's their choice and they will actually get their plan done, that's the second best result in my mind. I've run over this morning. I apologize. Most of you hung with me. I really appreciate that. I would like to thank you so much for your time this morning. Again, we'll be talking about a similar subject in the next 2 months, so I'd love you to join then too. I look forward to seeing you all out and about in our beautiful corner of the world. And I am John Miller, founding attorney, Rock Solid Law and Title. Here's the Commodores. And if that is not a 1970s synthesizer sound, I'm not wearing a bright shirt today. Thanks for joining me, everybody. Have an awesome day. Talk soon. Nice to see you, Art. Thanks for being here, Andy. Margie, great to see you. Take care, everybody. Over and out. You are so welcome, Andy and Wanda. Bye now.